What's going on, YouTube? Listen up, young elder gang. This is billionaire Ted Strokes at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. All right, let's get started. The Racketeer Influenced and Corrupt Organizations Act, or RICO, sounds like something out of a gangster movie. It was originally designed to go after the mafia, those folks with the fedoras and the questionable cannoli recipes. The idea was to dismantle organized crime by targeting their entire enterprise, not just individual offenses. But RICO's scope has expanded. Keep in mind the USA Corporation reincorporated in Puerto Rico after they bumped Lincoln off for bankrupting them, the rich port. This is also where the World Boxing League is, and they say it's owned by private shareholders. I wonder who those private shareholders are. Could it be the same private shareholders who own the Federal Reserve? You know, the Black Hand and the Lords of London. You think there's a connection there? The RICO is no longer just about busting up the mob. It's become a tool for all sorts of things. Think environmental protests, political groups, even journalists. Suddenly, that image of Rico taking down a bunch of guys in pinstripe suits seems a little less glamorous, doesn't it? So, Rico was supposed to go after organized crime, but now it's being used to target a whole host of groups and activities that are a far cry from the Corleone family. We're talking about environmental activists, political dissidents, rappers, music artists, athletes, entertainers, militant black organizations, black nationalist groups, even black politicians. RICO's definition of racketeering activity is about as clear as mud. It includes a laundry list of offenses, from fraud and bribery to gambling and murder. These vague terms give the feds a lot of wiggle room. All they need are 2 or more predicate acts, crimes that fall under RICO's sprawling umbrella, and boom, you've got yourself a racketeering case. Once the RICO label is slapped on, you're looking at serious charges, hefty fines, and potentially decades in prison. Now let's talk about what goes on in those hallowed halls of justice. You'd think that with RICO's immense power, the courts would be extra careful, right? They'd demand rock-solid evidence and ensure a fair trial, wouldn't they? The government holds all the cards. They have vast resources, teams of lawyers, and the ability to offer deals to witnesses in exchange for testimony. And the judges? Well, they're not always the impartial arbiters of justice they're supposed to be. It's enough to make you wonder if Lady Justice has traded in her blindfold for a pair of rose-colored glasses. Secret societies and hidden agendas. Now buckle up, folks, because we're about to venture into some seriously murky waters. Some folks reckon that RICO is being used to target groups that pose a threat to powerful interests. We're talking about groups that challenge the status quo, expose corruption, or threaten the bottom line of big corporations. These shadowy figures use RICO to silence their critics. They slap them with trumped-up charges, tie them up in legal knots, and drain their resources until they're forced to shut up or give in. When you see RICO being used again and again to target groups fighting for social justice, environmental protection, or government transparency, or someone like P. Diddy, who lost his seat at the high table, well, you start to wonder, don't you? RICO's commercial interests. Let's not forget about the money, because oh boy, is there a lot of money involved in RICO cases. We're not just talking about fines and penalties, although those can be substantial. No, we're talking about asset forfeiture, a legal tool that allows the government to seize property and assets allegedly connected to criminal activity. The government doesn't have to prove you're guilty beyond a reasonable doubt to seize your assets. They just have to show a preponderance of evidence linking your property to a crime. And the worst part? The government gets to keep the proceeds from any assets they seize, even if you're later found innocent. It's a system that creates a perverse incentive for law enforcement to go after deep pockets, regardless of guilt or innocence. Fighting back strategies for defense. So, what can you do if you find yourself facing a RICO charge? Well, the first thing is, don't panic. The most crucial step is to find yourself a good lawyer, someone who knows the ins and outs of RICO law. They'll help you navigate the complexities of the legal system, challenge the government's evidence, and protect your rights every step of the way. It's also crucial to understand the charges against you, gather evidence in your defense, and be prepared for a long legal battle. By understanding your rights, building a strong defense, and refusing to be intimidated, you can level the playing field and protect yourself against the overreach of RICO. People are under the impression that Cointelpro operation stopped in the 1960s. The truth of the matter is, they just changed their name. Overstand as long as the Federal Reserve exists. The Cointelpro will exist. The conviction rate for federal prosecutions is generally considered to be over 90%. This is because they spend years watching and studying you. One of their tactics is to create a negative public image for target groups, for example through surveilling activists and then releasing negative personal information to the public. Break down internal organization by creating conflicts, for example by having agents exacerbate racial tensions or send anonymous letters to try to create conflicts. Create dissension between groups, for example by spreading rumors that other groups were stealing money. Restrict access to public resources, for example, by pressuring nonprofit organizations to cut off funding or material support. Restrict the ability to organize protest, for example, through agents promoting violence against police during planning and at protests. Restrict the ability of individuals to participate in group activities, for example, by character assassinations, false arrests, surveillance. A March 1968 memo stated the program's goal was to prevent the coalition of militant black nationalist groups, to prevent the rise of a messiah who could unify the militant black nationalist movement, to pinpoint potential troublemakers and neutralize them before they exercise their potential for violence against authorities, to prevent militant black nationalist groups and leaders from gaining respectability by discrediting them to both the responsible community and to liberals who have vestiges of sympathy, and to prevent the long-range growth of militant black organizations, especially among youth. Dr. King was said to have potential to be the messiah figure should he abandon nonviolence and integrationism. 46 and Kwame Ture was noted to have the necessary charisma to be a real threat in this way, as he was portrayed as someone who espoused a much more militant vision of black power. 47. While the FBI was particularly concerned with leaders and organizers, they did not limit their scope of target to the heads of organizations. Individuals such as writers were also listed among the targets of operations. Cointelpro was a program of subversion carried out not by a couple of petty crooks, but by the National Political Police, the FBI, under 4 administrations. Its actions went as far as political assassination. To ensure the win in court, the feds use forged documents and by planting false reports in the media, harassment, wrongful imprisonment, illegal violence. Common tactics used by Cointelpro were perjury, witness harassment, witness intimidation, and withholding of exculpatory evidence. They say the reason for doing this is to protect national security, preventing violence and maintaining the existing social and political order. Withholding exculpatory evidence is when prosecutors or law enforcement fail to provide a defendant or their lawyer with evidence that could help prove the defendant's innocence. This is known as a Brady violation. Exculpatory evidence is any reasonable evidence that could lead a jury to find a defendant not guilty. The Brady rule requires prosecutors and law enforcement to turn over all exculpatory evidence to the defense. If the prosecution withholds exculpatory evidence, the defendant may be granted a new trial. In some cases, the prosecutor or law enforcement official could be charged criminally or sued civilly. Some reasons why prosecutors might withhold exculpatory evidence include failing to reveal crucial information, prosecutorial misconduct, and official misconduct. If the defense attorney believes the prosecution is withholding evidence, they can submit a motion to compel to the court. The court will then decide if the defense has the legal right to see the evidence. Suppression. The evidence must have been suppressed by the state, either intentionally or unintentionally. Prejudice. The defendant must show that prejudice resulted from the suppression. Brady violations are common in the federal criminal system. This is partly due to an unsettled area of the law regarding whether all favorable evidence must be disclosed or only evidence that is material. Some examples of Brady material include arrest photographs that don't match the victim's description, inconsistent descriptions of the crime or criminal by different witnesses, pending charges against a police informant. Police had other leads but didn't follow up on them. Potential consequences for Brady violations include excluding evidence, dismissing the charges, and punishing the prosecutors. Witness harassment is a type of witness tampering that involves using intimidation, threats, or other means to influence a witness's testimony or prevent them from providing evidence in a legal proceeding. Witness harassment is the act of using intimidation, threats, or other means to influence a witness's testimony or prevent them from providing evidence in a legal proceeding. The goal of witness harassment is to get the witness to make a false statement, withhold testimony or evidence, or miss a court proceeding. Witness harassment can include overt threats, violence, emotional manipulation, or creating a setting that discourages testimony. For example, a defendant in a domestic violence case trying to convince their wife that pushing her down was an accident could be considered witness tampering. For example, an agent of the government force a person to falsely testify to protect themselves or other family members for prior crimes they have committed. Witness tampering can be a misdemeanor or a felony, with penalties ranging from a fine and jail time to a restriction on owning a firearm. Law enforcement officers can bring charges against a party, another witness, or anyone who attempts to witness harass. Anything done with the intention or purpose of preventing or altering a witness's testimony or report to law enforcement, or to retaliate against a witness for such testimony or report. Threats, verbal threats, written threats, or threats on social media. Physical force, using force to prevent a witness from testifying or threatening to do so. Financial bribes, offering money or other financial incentives to a witness. Confinement, keeping a witness in a place where they can't leave. Corrupt persuasion, blackmailing or pressuring a witness to change their testimony. Harassment, making nuisance phone calls, parking outside a witness's home or damaging their property. Threatening family, threatening a witness's family members, such as their spouse, children, or parents. Asking to not testify, asking a witness not to testify in court or to change their story. Witness intimidation can be a misdemeanor or a felony, depending on the circumstances. The severity of the punishment is based on the seriousness of the intimidation. For example, using physical force or threatening to kill a witness could result in up to 30 years in federal prison. Now, when I say illegal entries, you might be thinking about illegal immigration, which is when a foreign national enters a country without proper documentation or authorization. It is a controversial issue that is often associated with concerns about security, social, and economic implications. No, we are not talking about that illegal entries. We are talking about tactics used by the Cointelpro. Illegal entries is used to create a criminal history and background on an organization, so they can use it as evidence to drive their Rico case home. Back in the day, some guys that were on their list never made it to court. Sound like the mob, right? How illegal entries work is essentially, they recruit an informant from within the organization. They say this is the best way to get close to the person. Informants are individuals who supply information to the FBI on a confidential basis. They are not hired or trained employees of the FBI, although they may receive compensation in some instances for their information and expenses. Their idea is that if you watch someone long enough, you will find dirt on them or skeletons in their closet. Unfortunately, when you have an organization, not everyone that join might be good guys or not have a criminal background. So the feds use this to their advantage. Once they have caught their prey, they turn them out by using what they called leverage, which is the exertion of force by means of a lever. Also, leverage is the use borrowed capital for an investment, expecting the profits made to be greater than the interest payable. Leverage is a bond, and bonds are contracts. Once these informants turn, they are used to plant fake evidence, drugs, weapons, and etc. Stage and entice the organization to participate in criminal activities. All these things will be used to do wrongful imprisonment on the subject or target. Also, these things will be used to drive the Rico case home in court. Really, all this is nothing personal, it's just business. It's a way for the Lords of London, the Black Hand, and their conspicuous to steal assets from people they don't like. They are using Rico on P. Diddy so they can steal his assets. You know, teach him a lesson of who's in charge. Donald Trump, the same thing, like Judge Joe Brown said, it's all game. The Fourth Amendment of the U.S. Constitution protects people from unreasonable searches and seizures by the government. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things. The Fourth Amendment can be violated in a number of ways, including: what is without consent? A search or seizure that happens without the individual's consent is illegal. What is without probable cause? A search or seizure that happens without probable cause to believe a crime has been committed is illegal. What is without a warrant? A search or seizure that happens without a valid search warrant is illegal. A valid search warrant must be filed by a law enforcement officer, signed by a judge, and state the place to be searched and what items are being sought. What is unreasonable search? A search that violates a person's reasonable expectation of privacy is considered unreasonable. For example, a dog sniff inspection that violates a person's reasonable expectation of privacy is invalid. What is electronic surveillance? Electronic surveillance is considered a search under the Fourth Amendment. This means phone taps, bugs, hidden cameras, mic wires, and etc. What is anonymous tips? The use of anonymous tips to justify a search or seizure can violate the Fourth Amendment. If a person is searched illegally without probable cause, any evidence collected from the search will be excluded from evidence at trial. This is known as the exclusionary rule. What constitutes an illegal search and seizure? Generally, a search or seizure is illegal under the Fourth Amendment if it occurs without consent, a warrant, or probable cause to believe a crime has been committed. However, there are several exceptions to the warrant requirement. What is the Fifth Amendment and how is it violated? The Fifth Amendment of the United States Constitution protects citizens from violations in several ways, including: what is due process? The government violates due process when it doesn't treat people fairly in legal proceedings. For example, a prosecutor might violate due process by not disclosing evidence that could indicate a defendant's innocence. What is self-incrimination? The Fifth Amendment protects people from being forced to incriminate themselves. If law enforcement doesn't give a suspect a Miranda warning before questioning them, any statements they make can't be used in court. What are takings? The Fifth Amendment's Takings Clause protects private property owners from having their property taken by the government without just compensation. The government can take property for public use, like building a highway or park, but it must pay the owner for the loss. Even if a person is guilty of a crime, the Fifth Amendment demands that the prosecutors come up with other evidence to prove their case. If police violate the Fifth Amendment by forcing a suspect to confess, a court may suppress the confession, that is, prohibit it from being used as evidence at trial. A violation of the Sixth Amendment can occur in several ways, including: what is a speedy trial? If a criminal defendant's right to a speedy trial is violated, the court must dismiss the indictment or reverse the conviction. The court considers the following factors to determine if a violation occurred: the length of the delay, the reason for the delay, whether the defendant requested a speedy trial, whether the delay prejudiced the defendant's ability to receive a fair trial. What is eliciting incriminating information? The government cannot deliberately try to get incriminating information from an accused person without defense counsel present. This includes police interrogation, undercover agents, or officers making statements to get incriminating remarks. What is peremptory challenges? Prosecutors cannot use peremptory challenges to exclude jurors based on race or sex. This means that it must be shown that minority jurors have been excluded over a series of trials or years. What is right to counsel? The accused has the right to have an attorney present for their defense, and they can also waive counsel and represent themselves. Despite adequate representation by counsel, if it is not the accused's counsel of choice and if he is erroneously prevented from being represented by the lawyer he wants, then the Sixth Amendment right has been violated. Criminal procedure is the adjudication process of the criminal law. While criminal procedure differs dramatically by jurisdiction, the process generally begins with a formal criminal charge with the person on trial either being free on bail or incarcerated, and results in the conviction or acquittal of the defendant. Criminal procedure is the set of rules and regulations that govern the process of investigating, prosecuting, and punishing crimes. It also protects the constitutional rights of individuals. The criminal procedure process varies by jurisdiction, but it generally includes the following steps. A formal criminal charge is made. The defendant may be incarcerated or released on bail. The defendant is either convicted or acquitted. The Federal Rules of Criminal Procedure, FRCP, are a set of rules that govern criminal cases in the federal court system. The FRCP's main goal is to ensure that every criminal proceeding is determined fairly. The FRCP aims to make the procedure simpler, ensure fairness in the administration, eliminate unnecessary expenses and delays, and protect the rights of those accused of crimes. The Supreme Court first adopted the FRCP in 1944, and it has been revised since then. Criminal procedure establishes rules for investigating, prosecuting, and punishing crimes while protecting individuals' constitutional rights. Key purposes include ensuring fairness and protecting due process and equal protection. We've been talking all about what Fourth, Fifth, and Sixth Amendment violations look like. We've talked about all the different ways that the government can violate a person's Fourth, Fifth, or Sixth Amendment rights in a criminal procedure context. So now we want to talk about what the actual effect of these violations are. We know what a Fourth Amendment, a Fifth Amendment, a Sixth Amendment violation looks like, but what now happens to the evidence obtained as a result of that violation? Is that evidence going to be admissible or inadmissible? And to deal with this, we have the exclusionary rule in the fruit of the poisonous tree doctrine. And our starting point rule is actually really straightforward evidence obtained in violation of the Fourth, Fifth, or Sixth Amendment, or as a result of the violation is generally inadmissible unless one of these exceptions applies. Fourth Amendment violations. This could include evidence obtained from a search without a warrant when one was required, a warrant that was too broad, or a search conducted without probable cause. Fifth Amendment violations. This would involve a confession obtained through coercion, interrogation without informing the suspect of their right to remain silent, or without providing an attorney when requested. Sixth Amendment violations. Evidence obtained during questioning when a defendant did not have an attorney present despite requesting one would be considered a violation of the Sixth Amendment. There are several exceptions to the exclusionary rule, including good faith. Evidence obtained by law enforcement officials in good faith can be admissible. This applies to officers who reasonably believed they were acting legally, even if the search warrant was later found to be defective. Independent source. Evidence can be admissible if it was discovered independently of a tainted source. Inevitable discovery. Evidence can be admissible if it would have been discovered anyway, even without the tainted source. The court must find that the evidence would have been discovered regardless of the illegal search. Attenuation. Evidence can be admissible if the connection between the evidence and the illegal means of obtaining it is remote. This means that intervening factors such as time or actions by the defendant have made the connection so remote that it's no longer legitimate to suppress the evidence. Impeachment. The government can introduce illegally obtained evidence for impeachment purposes. Plain view. Evidence can be seized if it's seen in plain view during lawful duties. For example, an officer can seize drugs seen in a driver's back seat during a traffic stop. Consent. Evidence can be obtained without a warrant if someone voluntarily consents to a search. However, the defense can challenge the voluntariness of the consent. The exclusionary rule prevents evidence obtained through illegal searches and seizures from being used in court. Searches made during a lawful arrest. Evidence found in plain view of an officer. Searches made with the consent of the person or property owner. Good faith reliance on a defective warrant. The fruit of the poisonous tree is a legal metaphor that refers to evidence that is inadmissible in court because it was derived from illegally obtained evidence. The doctrine states that if the source of the evidence is tainted, then anything derived from it is also tainted. The doctrine was established in 1920 by the decision in Silverthorne Lumber Co. v. United States. The phrase, fruit of the poisonous tree, was coined by Justice Frankfurter in his 1939 opinion in Nardoni v. United States. The doctrine is also known as the derivative evidence doctrine. Some examples of the fruit of the poisonous tree doctrine include: a police officer enters a house without a search warrant or probable cause and finds illegal drugs. The judge rules that the officer violated the Fourth Amendment and the case is dismissed. A police officer pulls over a driver without probable cause and searches the vehicle, finding an illegal firearm. The judge rules that the firearm is inadmissible in court. Fruit of the poisonous tree doctrine, a rule under which evidence that is the direct result of illegal conduct on the part of an official is inadmissible in a criminal trial against the victim of the conduct. That's all we have for you today, young elder gang. Hit that like and subscribe button. Matthew 5:10 says, "Blessed are those who are persecuted for righteousness' sake, for for theirs is the kingdom of heaven. We out, amen.